Everyone, as you're logging in from the waiting room, I'm going to go ahead and launch the closed captions. So that takes a few seconds, and then you'll see a red live button at the top of your screen. And you can click on that to be taken to a separate screen if you would like to watch the closed captions. All right, those should be up and running. Oh, I am so excited to see the demand for this information today. Welcome, everyone. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services, and I am delighted to have with us again our superstar, Robin Rosenberg. She is always willing to jump in and do a training, and she said there's been so many legislative updates. We've got to do this, so I really appreciate her doing this and putting it together so quickly to keep everyone up to date. So Robin Rosenberg has been the Deputy Director of Florida's Children First since 2007. She is amazing. So without further ado, I will let her get to all this great information.
Hi, everybody. Thanks for joining us. And I want to let you know that the materials, the slides that I'll be showing, and the chart that I'll be referring to at the end are available. They will be sent to you from Zoom probably tomorrow. So if you don't get them, check your spam filter, because they often go in the spam filter. And then ultimately the video and the link to the materials will be posted on the Florida Legal Services YouTube channel. So you'll have access to the materials. Please feel free to type your questions into chat. I'm not going to be able to see them, but my colleague Christina Spadeas and Christy Baglow from Florida Legal Services will read questions to me. I'll stop at different points throughout to try to answer questions. We have lots of things to cover today, so I'll try to get to as many questions as I can, but I do want to make sure that we touch on and cover all the main material. So as you know, Florida's Children First is a statewide legal advocacy organization that's focused on the rights of children. And so I will tell you that what you hear from me today about what happened in the legislature is going to be through that lens. So if you get an update on legislation from the Florida Coalition for Children, that will be through the provider lens. If you get it from the GAL or for DCF or from parents attorneys, that will be through their lens. So I'm admitting to you, you're going to get this law through our lens, which we believe is the lens of the children. So give me 1 second and I am going to share my screen and we will get started. It's a little, let's see. Okay, hopefully you all can see the main screen for the legislative update. So before we get started, for all of those of you who are attorneys, please take a minute, if you're not already a registered user of the Florida Dependency Law Center, after the training today, go to the website floridadependencylaw.org and register as a user. We send updates and material and have resources and the ability to communicate with colleagues all through the Dependency Law Center. It's a free site and it's a place that if you want to stay on top of things, it's the way that we can be in touch with you as things are happening. So I've put the slide in here and then again at the end, it's floridadependencylaw.org. So what we're going to cover today is what passed, what failed, and we're going to go over the updated independent living benefit chart. And again, that will be a separate document that will be sent to you tomorrow when you get the Zoom link. All right, so the overview of what passed, we have some really big bills that we'll spend a lot of time on and some little things that we'll just go over a little more quickly. So I want to tell you how you can get these laws. The easiest way to look at Florida statutes, I find, is by using the Center for Child Welfare website. They have all of Chapter 39 in one document. So if you're searching for something and you're not sure what section it's in, you can just do a search and find for the entire chapter. The official law is at the online Sunshine. And when you're looking at new law, some of the things that we're going to talk about have not gone into effect, have not been signed. So when I'm talking about a bill that hasn't been signed, I personally like to use the Florida Senate website to pull up the bills. So that's how you find the law that we're talking about. first one I want to talk about today is in the education realm. Um, I'm sure there were more education bills, but this is not my area of expertise and not the purpose of our conversation. But there's one thing I want to point out to you, that the seclusion and restraint bill that was passed, House Bill 149, is a culmination of many years of efforts to try to improve the situation for children. And these are children who have usually behavior issues and often disabilities that cause behavior issues that have resulted in them being secluded, put into seclusion rooms, or physically restrained, sometimes with things like straitjackets or wrapped up in like a burrito. It's very traumatizing to children, very traumatizing to children that have been involved in the child welfare system. So past bills have addressed data collection. That data collection is addressed in this particular bill. If you look at the staff analysis, it'll talk about how many thousands of times children have been restrained in different school districts. So the Senate bill, the House bill precludes the use of seclusion. We're not going to isolate children. That's not timeout. You can do timeout, but no seclusion anymore. It limits restraints to authorized personnel just when there's a risk of imminent serious injury. And importantly, requires the promotion of positive behavior supports. And it creates a pilot project to put video cameras in some classrooms. So this affects, unfortunately, a lot of kids involved in the child welfare system, which is why I included it in these materials. The next bill I want to talk about is the a couple of juvenile justice bills that also affect a lot of the kids that we talk about in the child welfare system. Well, first, we have now passed a law in Florida that we cannot arrest children under the age of 7. When the bill was filed, it was the age of 10, but it got pushed back. And now we can only arrest them if they're alleged to have committed a forcible felony, which means treason, murder, manslaughter, sexual battery, carjacking, etc. So we've now got the idea that actually arresting children is not a good idea and doesn't promote public safety, and hopefully we'll stop doing that. In the diversion and expunction realm, this is, again, pretty exciting. Young people have been limited in the past to expunging records if they went into diversion only for misdemeanors. And so the law has changed, and now they can get expunction of their records if they were alleged to have committed a felony. And so there's a confidentiality provision and permits young people to deny or fail to acknowledge the arrest if they successfully participate in a diversion program. So this could also affect a lot of our kids from care. They made a change in juvenile detention law and programs. Now, this was talked about in the news from the sheriff in Volusia County recently, complaining about making it more difficult, that the recent legislature was going to make it more difficult to detain children. And that really is not what this bill did. House Bill 885. What it did was it added factors for the court to consider in deciding whether a failure to appear was willful. So now, before just saying the kid's supposed to be here, the kid's not here, we can detain them, it has an inquiry into these factors to determine, did they know, did they get notice, etc. So it doesn't really change who can be detained. It just says, let's be reasonable and let the court determine whether the kid actually had notice. It changes the cost sharing between the counties and the state with regard to detention. I'm not an expert on it. The analysis said that it really wasn't a change in the practice, but a cleanup in the law to match what current practice was. And it also requires communities to work on incentives and consequences to address technical violations of probation. So again, we don't want to detain kids that don't need to be detained. We need to have alternative consequences if they're committing a technical violation. And it requires some work between DJJ and the Department of Education to look at education models for providing education to youth and care and DJJ care. So let's take a quick break. And are there any burning questions on those education and JJ related bills? Christy, anything I need to?
Any questions yet?
Okay, then let's keep moving. All right, then we're going to start with what I call the child welfare odds and ends before we get to the big bill. So the first bill that I'm going to talk about is Senate Bill 52. And all it did was put 2 commas into existing law to make sure that everyone understands that if a kid's in foster care finishes high school before 18, they can use the tuition exemption to go to get free tuition in college. So it's always been the law, but people had a hard time reading it. And now it's got those commas where it says a student a student who is, comma, or was at the time he or she reached 18, comma, and the custody of the Department of Children and Families. So tiny little thing, but impacts a lot of kids. It's been a crazy question. That bill was signed on June 24th. The next one is a bill that gives sovereign immunity to members of the Child Protection Team when they're acting under the control of the state. So right now, in some parts of the state, Child Protection Team members are physicians, especially that work in public hospitals like at Shands or University of South Florida. They're already covered under sovereign immunity. But there are parts of the state where the doctors and other professionals involved are not state employees, and this gives them sovereign immunity when they're acting in the Child Protection Team. That was signed into law on June 21st. Okay, so now we're going to get to the big bill, Senate Bill 80. Senate Bill 80 was presented to the governor this morning, so it has not been signed yet. If it is signed, it will go into effect on October 1st. And we have every right to expect that it will be signed into law. So it is not yet, but we expect that it will be. So this Senate bill we call a train. If you're familiar with the legislative process, this will be familiar to you. If you're not, the train is a bill that everyone knows is going to pass. And so lots of other little things, either entire bills or parts of other bills that people really want to get passed, they will add on to a bill that they know is going to make it through. So Senate Bill 80 is the first train that we're going to talk about and really spend the most of our time on today. So while we're talking about it, I want you to think about some underlying themes that will come up as we look at different sections of the bill. Last year, legislation was very focused on accountability and creating accountability within the Department of Children and Families and oversight by DCF to the community-based care lead agencies and their subcontractors. This year, the themes are really looking at good social work decision-making, getting good decisions for kids. And you're going to see a lot about child well-being, attachment, stability, siblings, family connections, promoting family and youth engagement, and respecting and supporting caregivers. So these will be themes throughout, especially Senate Bill 80. And I like this term on my scales of justice. It's a term my father used to use a lot, the convenience of management. And that's when decisions are made because they're easy, they're comfortable, they, they're done for the management's convenience, as opposed to what this system is about, children. It's about children. And the legislature this session is putting the thumb on the scale on what is best for children. So some of these things may be inconvenient for agencies or parties, but they're done because it's what's best and right for children. And so I want you to keep that in mind as we're looking at some of these provisions. So the first provision in this, in Senate Bill 80, requires DCF to develop a face sheet for each file. And at first I thought, well, what's that? Like, who cares? But then really think about it. And if you look at the staff analysis, it was pretty interesting. It talks about how the medical field uses this. And quite frankly, as an attorney, when I handle litigation, I would have something like a face sheet for my files. And if you're going to hand a file to a colleague to take a matter for you, they should be able to pick up that file really quickly and see all of the key points to know what's going on in the case. And that's what the legislature is requiring from this. A face sheet is a summary of the pertinent data. Where is the kid now? How many placements have they been in? Where are they in school? Who are the key people? What is their contact information? It has to be in a uniform format that can be printed out so everybody can have access to it. And, I've seen, I've never seen the electronic file, but I have seen hard copy files, huge files of documents, and you've got to go through each section to find the information you need. So this requires a summary to be upfront and available at the beginning of the file. It has to be updated monthly. And what I'm finding interesting about this is that it has to include the names and I presume contact information for all of the attorneys assigned in the case in all capacities. And we know right now that the FISFIN, the electronic record, does not track children's attorneys. So I'm excited that that's going to have to be included because right now they can't tell you by doing a data search which children have attorneys. So that will be an interesting update to current practice. The next section I want to talk about, okay, this is like you can tell a pet peeve of mine because I went out of the way to get some pictures for you. Children are not potted plants. We have, through the history of the child welfare, treated children like, oh, it's not working out here, we can just pick them up and move them there. This person's not convenient, so we'll just pick them up and move them there. That daycare doesn't work anymore, we'll just pick them up and move them to a different daycare, without thinking about the impact on children. And so this next section is a brand new section of Chapter 39, and it is just about a best interest determination of when is it in a child's best interest. How do you decide which placement is in the child's best interest? And it sets out 15 factors that are to be considered every time you're deciding, does the kid go here or does the kid go there? Or what are we looking for a placement? And each child should be considered individually for their needs. Now I'm going to note on number 5, again, a pet peeve as a children's lawyer, reasonable preference of the child if the child is of sufficient age and capacity to express a preference. And I will tell you that almost all children can express a preference. They might not be able to write it to you. They may not be able to tell it to you in language of, I would prefer to live with my grandmother over my aunt. But they can tell you what they want in other ways. And so as a kids advocate, I would say always argue for what your child wants, and show how that preference is expressed. So, and here's the remainder of the list. I also want to point out to you item number 14, which is the impact on access to education, Medicaid, and independent living benefits. And got my asterisks there to look at the independent living benefit chart, which we're going to talk about at the end of this presentation. When you're deciding whether a child is going to remain in a foster home or move to a non-relative and leave the custody of the state to live with a non-relative, that has an impact on their access to benefits. And everyone involved, the child and the caregivers, need to understand what that impact is. And that's the point of the independent living benefit chart, is so that everyone understands what all the factors are and that there are no surprises when someone turns 18 and was expecting to get a benefit that they now find out that they can't get. So that is a factor to be considered in the best interest determination. So I'm going to pause real quickly and see, are there any questions at this point, Christy?
So we had a couple come in along with many compliments about what an amazing advocate you are and that they love the information about placement and how important it is to focus on the child. Since we've got the list in front of us, there was a question, are these listed by priority or in no particular order?
You know, I copied the list directly out of the statute. And I don't think the statute says in this priority. These are the 14 actual factors along with number 15 other relevant factors. So that is the place for you to make your argument about what's best and right for a kid, because there may be a factor that's not on that list that the court should consider. But I don't believe that they are, you know, in a legal priority.
We had some questions about the face sheet you mentioned. What is the difference between the face sheet and a child resource record?
So a child resource record is the whole record. And in some places, that's the term that's used for what is handed to the caregiver, the documents that are provided to the caregiver so that they have the basic set of documents. A face sheet is going to be 1 to 3 pages. That's a summary of the information that's found in the child resource record, but all put into one place. That you don't have to flip through to see, you know, last school year, where did they start school and when did they change and when did they change? It would be right up front. They were in 3 schools last year. And, you know, mom got a new attorney 6 months ago. You don't have to look to find out who the current attorney is. It's going to be in the face sheet.
That kind of answers the second question, which was, is the face sheet limited to 1 page? So you said 1 to 3 pages is okay.
Yeah, I mean, I don't think that, that didn't specify how long the face sheet had to be. The law does specify what has to be on the face sheet. So it'll be as long as it takes to answer all of the questions, all the components that are in the statute.
One last question before we move on. Regarding the best interest factors for placement, will a finding have to be made on each of the factors? And will these factors have to be considered when sheltering?
It does not specify that the court has to make a finding on each particular factor. You know, what the Juvenile Rules Committee does with the law in creating the juvenile rule and the form remains to be seen, but the law does not require that. And yes, best interest is to be considered at the time of shelter and every time a placement decision is being made. And so what you'll see is throughout the rest of chapter 39, it's been updated to refer back to best interest factors. And so the next section, does that cover all the questions for now?
One came in just, will each circuit have discretion to develop their own face sheet, or will there be a statewide form?
I believe there is going to be a statewide form, but I can't say that with certainty.
All right, thanks. That's it for now.
Okay. So the next component, so now we have the statute that says, this is what's in the best interest of kids. This judge, this is what you need to think about when you're thinking about best interest, and everybody else, right? When you're making decisions. They also put into the statute priority of placement. We have not had a specific priority. So, and again, whenever the kid is coming in or being placed, we're going to look at this priority. So the first top priority is go to a non-offending parent, then a relative caregiver. Then it kind of got moved around in different versions of the bill, but what it ended up with was after relative caregiver, adoptive parent of a sibling, then fictive kin with a close existing relationship. So this is your best friend, your kid calls auntie. And after them, a non-relative caregiver that doesn't have an existing relationship. The secretary at the church who heard about the situation is willing to step up, but maybe doesn't already have a relationship with the kid. Then licensed foster care. And then the last one is group or congregate care. And this really fits in with, you know, remember on October 1st, under the Family First law, the feds are only going to pay for the first 14 days of group care unless there's a specific treatment need. So we put group care at the bottom of that priority list. In that section on priority of placement, it has a specific discussion of what happens when sibling groups are coming in. And again, I want you to think about this legislation is dealing with social work practice that good social work practice has been and should always be in place in decisions that are being made in the child welfare system. But there are times when good social work practice does not happen or is not articulated to everyone involved. And we had some major case that was reported on in the newspaper that related to the separation of siblings, and which really caused them to look at what is that practice with relation to sibling groups. And so the legislature stepping in to codify what it thinks good practice should be. So when sibling groups come in, they have to be placed in the same placement whenever possible. But also, if placement together is in the best interest of each child in the sibling group. And so we tend to have like hard and fast rules. Siblings should always be placed together. Little kids should be never moved. And what this this whole bill is trying to do is strike that balance and make sure that thoughtful decisions are made. Yes, siblings should always be placed together, except sometimes maybe they shouldn't if there's a good reason. And you have to look at it from the perspective of each child in the sibling group. And then there are two additional new statutes that have to be considered in sibling placement. So again, we're in the priority of placement law. And that's what we're talking about here. But then there are these adjacent new statutes that are in effect. So in the priority of placements, and this is really key, and I try once in a while to highlight some terms. Priority of placements applies to all changes of physical or legal placement at shelter, after shelter, and before permanency. So we sometimes have a distinction that if the child is placed in foster care, that's in the legal custody of DCF. And so moving from one foster home to another foster home is not a change of placement because it's not a change of custody. This priority of placement is making it clear that it applies to changes of physical placement change, not just legal custody. It does exempt out placements regarding a adoption intervention. But then as you see, the priority placement specifically is now referenced in prior to shelter in 39401, at shelter 39402, and in post-disposition change of custody. So those laws have been updated to match this priority of placement. I'm going to go ahead and do the multidisciplinary teams, and then we'll come back and do some more questions. So there's another new section of the statute, multidisciplinary teams. And the premise of this is that people coming together, the professionals, the family, the people that live it, will get the most positive and best long-lasting outcomes, better family engagement, and shared commitment and accountability from the circle of support. Lots of folks have been using multidisciplinary teams. Maybe you're calling it family team conferencing, and maybe you call it a family meeting. But the underlying theme is you're going to get better social work decisions. So there's already some law that mandates MDTs. This is adding to that. Okay, so under this section, MDTs have to be held before the first placement, and if it's not possible, as soon thereafter. Whenever there's a change in physical custody, change in educational placement, decisions regarding sibling groups, and other important decisions that are so complex that DCF and the lead agency need to be involved in them. So, and this, again, coming out of some high-profile situations where decisions maybe were made, and maybe they were made with good social work basis, but not communicated to the people involved. And so there's suspicion and rumor and misunderstanding. And, there's a rule that says when a baby is born, it should be placed into the foster home with the existing foster parents. And the law actually already says that. There may be a good decision made that that foster parent and that mom are not getting along well enough now, and it would impair the mom's ability to bond with her child. So we're not going to follow that law. We're going to place the child somewhere else. That's fine. That's a reasonable social work decision about what's best for kids. But when you lie to the foster parent and tell them, we didn't know you existed, then you've got a problem. So the point is to bring the people together, get good decisions to be made. So the fact that these points in time require a multidisciplinary team does not preclude any other place where a multidisciplinary team is required. And this particular section does not apply to MDTs that are being held by a child advocacy center, and again, for adoption intervention. There are mandatory participants in a multidisciplinary team, and that includes the child, unless the child is not of age or capacity to participate, the child's family and other people identified by the family as being important to the child, the caregiver. And this next one I think is very interesting. It's a DCF representative, but it specifically says not the Children's Legal Services attorney if DCF is involved in the goal that's being discussed. The CBC lead agency representative and the child's case manager or supervisor. Staffings cannot be delayed if somebody does not attend, as long as they've been given a reasonable opportunity to attend, and the attendance can be in person or virtual. So those are the mandatory participants. And then there are additional what they call professional participants who can be invited as appropriate. And there's a list of them there. So that's who is supposed to be there. There are specific goals for MDTs that are supposed to be considered in every multidisciplinary team staffing. And they're fundamental themes of good decision-making, attachment, stability, family engagement. So every time they're making a decision, that team is supposed to keep these comprehensive goals in mind.
You have several questions on those topics. Maybe you might want to go over.
Okay, I think I'm going to do a couple more slides on MDT, kind of get the whole thing on MDT, and then we'll stop there. So when they're making decisions, they should be using data and information, using assessments if they can be done, but the decision making should not be delayed because a screening or assessment has not been conducted yet. And I just want to give a reminder, this, when we're talking about placement decisions, this is actually not a new requirement. 39.523 placement and out of home care already requires an assessment in relation to placement. So this is pulling it together into the team decision making. There are specific considerations when we're talking about young children, really things that we have to think about in their ability to form healthy attachments, to remain connected to their family. And when you're looking at caregivers, potential caregivers for young children, how willing are they to make sure to do what they need to do to help that child have healthy attachments? So they're written in statute, specific sections for young children. And then the last piece on multidisciplinary teams is what happens with decision making. And this also, I think, is very important. If that team, and remember our mandatory participants are including DCF and the community-based care lead agency, if the team has unanimous consensus, the decision is the official position of the lead agency and it's binding on DCF and the lead agency. So that team meets, they make a decision, everyone's in agreement. Everyone in that room has the right to rely on that decision. They are bound by it. If they don't reach unanimous consensus, then the facilitator will notify the court and DCF will make the decision about how to identify the goal that's in the staffing. There's a report process to go forward on that. So that's the capsule of multidisciplinary teams and priority placement. So it sounds like we got a bunch of questions. So let's take
lots of questions. You're keeping everyone on their toes. Okay. So I'm going to try to merge some of these questions together so we don't take too long. There were a lot of questions about the multidisciplinary teams, about guardian ad litems and attorney ad litems. Are they not allowed? Are they optional?
So the guardian ad litem is specifically listed as an additional professional participant. The child's attorney is not specifically listed in there. And, I think as a child's attorney, I would assert that I'm somebody important to the child and to be part of it, but they are not listed in the statute, nor are they specifically precluded, which the CLS attorney is.
Okay, that was one of the questions. So the CLS attorney is prohibited from attending the MDTs.
Well, I don't think the language says that they are prohibited from attending. What it says is that they are not DCF's representative on the MDT.
Okay. So this is a related question. Are attorneys for the parents part of the MDT meeting?
Attorneys from the parents, like attorneys for the children, are neither listed nor precluded.
Right. And then just to clarifying, MDTs, does that refer to Children's Advocacy Center MDTs?
No, it
Okay.
specifically separates out the Children's Advocacy Center MDTs as not falling under this law. They have their own rules and continue to operate separately.
Okay, so back to placement away from MDTs. Is the non-relative placement without a relationship to the child due to the parent being more comfortable with that placement? Are there any training requirements?
So this law doesn't change the existence of non-relative placements that are currently under 395035. I forgot that 5035, I think. So this law does not have any current training requirements. It just sets the priority for existing placements. And if a non-relative is willing to take custody of a child and wants to become licensed as a level 1 caregiver, then there are training requirements that attach to that. But there aren't training requirements that attach just to placement with a non-relative under existing law.
A question, what if the foster parent or relative moves? Does that require consideration of the new factors?
The law does not talk about that as a trigger. I would presume whatever the current practice is now, if you're a foster parent in Hillsborough County and you decide to move to Orange County, that's the discussion you have between your licensing agency and the CBC lead agency about whether a move is appropriate. But this law does not address that. The change in law doesn't address that.
For a couple more placement questions?
A couple more.
We're doing okay. Can the best interest factors outweigh the priority of placement? For example, if a child is in LFC for 6 months and a non-relative pre-adoptive placement is found, would continuity of care and bonding outweigh priority placement?
So I don't, the law does not put them in juxtaposition in that way. It is that individualized determination for each child. So if you're talking about the desire and the capacity to move a child into a permanent home, then I think the discussion would end up being about the transition and the timing, not about the priority, because getting to permanency is always a priority. So, but the law does not tell you how to counterplay those two factors.
How does the system consider placement with siblings in relation to siblings that have different fathers or paternal family members?
There are general principles regarding siblings that we're going to go over, but it does not get to that level of detail and decisions to be made.
Someone just wanted to let everyone know that DCF has allocated MDT coordinator positions for each region who will take the lead on this.
Great.
And then let's see. One more question. As a system, are we anticipating that the unified home study and legal documents will be modified to capture the language change in the new laws?
I presume that everybody that works on forms will do whatever updating they can do, but I'm not involved with any of that, so I can't say with any certainty. All right. All right, let's keep moving on because there's lots of ground to cover. And this relates to educational and placement changes. So again, a whole new section of Florida statute just talking about transition. And I want you to think about, my picture of my potted plants at the beginning, right? Every child is unique and their needs are individual. And so the purpose of this section is to be thoughtful about what we're doing with children and how and when and why we're moving them. This section is, I would say, a long time coming. So for those of you that have been around for many years, I think it was like 2008, 2009, DCF Children's Legal Services did panels on the trauma of removal and really learned a lot in hearing about the effects of moving on children. And then Florida's Children First and Florida You Shine, we did a series of trainings around the state on the trauma of removal. The legislature passed transition language in 2013 as part of Chapter 409, 145. You might remember the Reasonable and Prudent Parenting Act. And they talked about the need for making good transitions to benefit children. So again, we have what should have always been happening as good practice, not happening, and it is harmful to children to move them without transition. And I've included here in the PowerPoint a video that Florida's Children First made 10 years ago in 2011 that exemplifies what we heard from young people about how their transitions were happening. And you all have a lot of questions, so I'm not going to play it for you now, but you'll have the link in your materials. So this 10 years ago, we were talking about it, and we are still to this day in this place where we get orders that say, pick the kid up from daycare and move them to the new home. Show up after school, get their stuff, and move them to the next foster home. It's torture to children. And so this statute, the legislature felt needed to be enacted to take that transition language and make it even more concrete so that we're doing a better job for kids every day. So this section of the law applies to both educational transitions and placement transitions. And with education, that includes childcare and early education. It really does matter when you move a 2-year-old from one daycare to another. So they're all included. When you look at moving children, you have to have a good reason to move children. Again, it's not the convenience of the management, it's what's right for the child. And so they've cross-referenced in this section of 39, they've cross-referenced the reasons that are in 409, 1415. They didn't write them over, but they cross-checked it. The only time we should be moving children are those specific reasons. And that applies, sometimes people don't like to look at a chapter 39. Well, now it's in chapter 39. It requires services to the family to try to prevent disruptions, whether that's a relative caregiver or foster home. When things are rocky, the effort really should be made. Can this existing placement be repaired so that the child can continue to be there successfully? If it can't and a move is required, a multidisciplinary team meeting must be held. And if a move is made in an emergency, then MDT has to happen within 72 hours. And of course, the new caregiver has to be provided information about the child that they will be expecting. To me, this is a really key provision. There is a requirement of written notice that the placement is going to be changed. And that written notice is supposed to include the reason why the change is necessary. How many kids have we talked to who have no idea why they went from here to there? They don't know what happened. Is it something they did? Is it something that happened in the home? They're just picked up and moved. So it requires written notice 14 days in advance, or if it's an emergency, within 72 hours after the move. It is to be filed with the court. And then there's a list of people that the notice has to be provided to. And if the child can't absorb a written notice, then the information has to be explained in a way that the child can comprehend. And so how many of you have represented a child or a parent who's not known that the child has been moved or where they've gone to? So that now there is a requirement of written notice. There's a requirement for a transition plan. And all of those people that are entitled to notice are supposed to be working together, cooperating to make a transition plan. And there's a specific prohibition on moving kids after 7 at night or before 8 in the morning. It's just about their best interests. And there are specific things, again, referencing back into chapter 409 of what needs to be included in that transition plan. They need to get their stuff. They need to be able to say goodbye to people. They need to be able to have continued contact unless there's a reason that it's not good for them to do that, right? So all of that needs to be in the child's placement transition plan. If they're done, again, moved in an emergency, it has to happen afterwards. And the plan also has to be filed with the court within 48 hours of its creation. There are specific provisions on transitioning infants that really talk about the brain science of young children and what their mental health needs are. And it talks about their needs at different ages and what needs to be in that decision at the time about whether to move a child. So specific factors if you're dealing with young children. In addition to physical placement changes, there are provisions that look at school changes. We all know kids should be able to stay in their school of origin, and we know they lose time and educational gains every time they're moved. So it sets out specific considerations for a determination of whether it's in the child's best interest to remain in the school of origin. It lists 15 factors that are supposed to be considered, but specifically says the cost of transportation is not a factor in deciding whether it's in the child's best interest to change schools. This is not the complete list of 15. I kind of merged some of them together, but it looks at, their educational gains, what's important to the kids, their extracurriculars, where they're at in exams, how it's going to affect credits, all kinds of things, and lots of factors that specifically look at the needs of children that have disabilities. The list of factors that were put into the statute are already in the administrative code, and they were added in after the Every Student Succeeds Act. So there's actually nothing new. They were just put into statute. It also specifically addresses the need to have transitions for young children and moving their early childcare settings. So specific things like that. And then it talks about what needs to be in a transition plan if there is a move of an educational move. So everybody knows what's supposed to be happening, including what's the detail, who's supposed to be making sure the kid's transported to school. There will be a kind of like a model or form transition plan. DCF is supposed to work with the Quality Parenting Initiative to create a form that is required to be attached to the face sheet. And this is it's a skeleton, it's an outline of what needs to be considered. But always remember, the whole point of this is to make individualized determinations for the child. So no longer is transition, 3 unsupervised visits, 1 Friday night overnight, 2 weekend overnights, and then we're done, right? The transition has to be thoughtful and unique to the child. So there's a section of law that talks about developing these model plans and explanatory material so that those of you that have to work on transition plans have something to work with and some tools to help you make good transition plans for kids. I can take a question or two on transition plans before we go to the next section.
You have a lot of questions, Robin.
Yes.
Okay, so and I've got a bunch more to do in 80. So
try to narrow it down. And Christina, you can jump in and help me with which ones we could narrow down, but I'm thinking.
Well, she's got time, I think, I think she's got time to do them all.
Here, okay, so are transition plans required for children moving into an adoptive placement?
yes.
That was easy.
Right.
How does the placement notification work with the kids who are frequently night to night?
Shame on us. I don't have an answer for that. Or we're torturing children when we put them on night to night.
I didn't even know that was a thing. That's news to me. I'm not sure what this is referring to. Does the relative taking the child have to absorb the cost then, or is the agency to pay for it? Maybe
So,
that's transition.
Yeah, I mean, then we're talking about, getting relative caregiver funds versus level 1 adoption and that whole process. And that's not part of the new laws don't address that. So the existing law and practice should not be changed by anything that is in this bill. And I'm happy to talk to folks offline about that, but it's not really changed by the law right now.
Does the statute state a priority in placement when there is a choice to either place a child with a sibling who is with a non-relative or not place the child with their sibling but with a different relative?
There's separate statute on siblings, which we will get to when I zip through the rest of it.
Perfect. So stay tuned. Is it specifically DCF CBC, or is there a person in particular who is responsible for notifying everyone? What happens if notice is not done?
I don't think the law specifies who's required to provide the notice. So I don't know how that will be worked out.
Will the disruption staffing be replaced with MDT staffing?
The law doesn't require that to happen. I could envision a disruption staffing kind of turning into an MDT staffing, but that'll be a local practice. It's not not mandated by statute.
When who is responsible for the transition plans and written documentation that will be provided to the court due to a placement change?
I believe it would be case management and then working with the CLS attorney, but I don't know that with certainty. I don't know.
If the current, they said there's often a request for emergency placement just because the current caregiver no longer wants the child in the home. So this person was asking if there's anything in the transition plan that addresses that, or if that's really not part of it.
Well, there's a requirement to offer services to try to mitigate that. And so anytime a caregiver says, I don't want to keep the kid anymore, the child welfare agency, the CBC lead agency, or the contractor should be working with that caregiver to find out what's happening, what the problems are, and offer services to try to ameliorate it, or at least if it can't be, to buy enough time to have a reasonable transition.
One more quick one on the same note. What happens if the caregiver is not in agreement, not willing to wait until the appropriate time to change placements? How are caregivers held accountable, particularly licensed foster parents?
That's going to be up to the licensing agency or the CBC lead agency, whether they're going to accept that type of behavior from their licensees. I certainly have heard of places that would say, if you tell me you don't want this kid anymore and you're not willing to give sufficient notice, then I won't be placing anyone with you for the next year. That's an internal management decision. It is not a statutory or rule decision.
Doing the lightning round, we're all done.
Okay, thanks. All right, so let's look at the next section of the statute, which is specifically on sibling placements. So whole section of statute just devoted to sibling placements. And I've highlighted what I think is the key part of this legislative intent. Although we presume that putting them together is in their best interests, overall the system is better when an individualized determination is made at each child and their ability to have healthy relationships. So siblings are extraordinarily important, but we're not having a blanket rule that places them above all other needs of all of the children involved. When we're talking about siblings, this statute and the basic definitions in 3901 have the same definition. The first one is one we would all commonly agree on: children who share a birth parent or a legal parent. But the law also says children who have lived together in a family with one or more other children who he or she identifies as siblings. So that includes foster siblings and step siblings. I think this is kind of often ignored, but it's what the law says siblings are. So it has specific requirements when we're looking at placing siblings, and it requires to look at what's in the best interest of each sibling, as well as whether there's an appropriate, capable, and willing joint placement. Excuse me. It specifically looks at the children that come in later and decides whether they should be placed in an existing sibling placement. And it does not mandate that that always happen. Again, looks at the stability of the placement and the best interest of the children. Every family is different. It could absolutely be the right best thing to have all those kids together somewhere, or it could be that even though they're siblings, they really have no relationship, and you would disturb a good, stable placement for a kid who was already placed. It does not require that children be moved in either their physical or legal custody to develop a relationship that did not exist at the time the kids were placed into care. We don't have to move kids to make a relationship that didn't exist. There are specific factors that the multidisciplinary team is supposed to look at in evaluating the relationship from the perspective of each child. And if the determination is made that they cannot be placed together, that's not the end of the story. It's the beginning of the story. And all the grownups involved need to work together to make sure that contact and visitation take place between children who are not living together. Again, several factors that are supposed to be considered in making that determination about sibling placement. If siblings are separated, the statute lists specific practices that should be considered. And that's, the support among caregivers to keep family ties together. It looks at and encourages other activities that can bring children together, and it explicitly prohibits withholding communication as a form of punishment. You stole money out of my purse, now you don't get to see your brother. Not an appropriate form of punishment. Restrictions on communication can be limited only when the court finds that that communication or visit is contrary to the safety or well-being of the child. And you'll all think of circumstances, maybe there's sexual abuse between siblings. Sometimes an older child is so parentified that it's really unhealthy for them to have that relationship. If that occurs, again, that is not the end of the story. The law requires DCF and the CBC lead agency to immediately provide services if they can be expected to ameliorate the risk. So it may be that they need to be apart, but it's our job to give them the services to come to a safe place where they could be in relationship again. And surely, if nothing else, the system should have services for that type of situation. If siblings are separated, there should be a periodic review. And if placing them together is not working out, services should be offered to prevent disruption. Or that doesn't work, again, an MDT to determine what is best for each child. And these are all considerations that have to be made pursuant to the statute. And then there's some really, to me, exciting parts of this law that are recognizing the rights of children. Number one, DCF has to notify the children with the contact information and location of their siblings. So many young people have told us how distraught they were when they did not know where their siblings were and could not communicate with them. So if the system knows, it has to tell the children. And if it doesn't know, they have to make reasonable efforts to find out. This is an important part of our being, and you should know where your siblings are. When siblings stay in care and have other siblings who leave care because they emancipate or reunify, the child in care has the right to continued communication. Now, if the person they want to communicate with is under the control of a parent or an adoptive parent, that individual could preclude the communication. But the first version of the bill risked, I think, some challenges on constitutional grounds of parental control. It was modified to recognize that it's important, there's a right, and the child has the right to go to court to ask for communication. And when the court is looking at doing an adoption, already in Chapter 63, there's a provision for ordered communication between the child and the siblings. And that needs to be consideration when we're looking at an adoptive family, the willingness of the adoptive parents to maintain communication with the siblings. So those are really significant changes on behalf of kids. I'm gonna keep going a few more parts of Senate Bill 80. The standard for changing legal custody in the post-disposition change of custody, some of those factors have been moved into other parts of the statute and out of 39.522 because they apply in several different places. There is a new provision about contested changes to physical custody. And so this comes about where a child has been in the home, often of a foster parent for a length of time. And then there's a decision made to move the child somewhere else, not to reunify, but perhaps a relative that's come forward or a caregiver of siblings. And decisions are made about modifying placement. At this point, under the statute, if the child has been in the placement for 9 months or more, and the caregiver is willing to become a permanent custodian and isn't asking for the change of placement, then there's a halt in the proceedings. The child can't be moved. The caregiver has the opportunity to contest that change of placement. The court has to look at those best interest factors, and it actually requires that the child be appointed an attorney in that process, and says you can't move the kid until the court order is done. Again, in response to a high-profile case played out in the media. So it creates a presumption that the child should stay, but it is a rebuttable presumption. The placement and out-of-home care talks about the comprehensive placement assessment. And again, this is not a new thing. It's already been required. It's just referring back to now the list of people on the team and the multidisciplinary team. Then we're going to talk about transition again, but this is the transition for young people who are about to become 18 and their transition to adulthood. So currently transition planning is required under statute at 17 and a half. The law moves it back to 16 and with periodic updates as needed prior to turning 18. It changes the judicial reviews. Again, those transition reviews to start at 16 and to start looking at those life skills and other provisions. So it's kind of a reorganization of what's existing in judicial reviews for 17-year-olds, now 16-year-olds. Entirely new section, reinstatement of parental rights. This is a concept. We've always had young people who were able to be adopted by their birth parents whose rights had been previously terminated. Now there is a statutory provision that permits the reinstatement of parental rights through a process, kind of undoing the TPR. The child has to be 13. Parental rights have to have been terminated for more than 3 years, and both the parent and the child have to want reinstatement. So there's a bunch of provisions that go along with the process for that, but it's exciting to have a recognition that that relationship can be recreated or reconstituted. The law was changed on aftercare services. They are now expanded to be available to young people who are receiving post-secondary education services and supports. So that's this cash that's available, that's been limited right now and is opened up a little bit. And I'm zipping along, guys, because there's still a lot to cover. And what I will be happy to do is stay on and take questions after, but I want to make sure we hit the highlights of these bills. There's a lot of work on staying connected to young adults who are formerly in care, and CBCs have to try to continue to do that. Changes to independent living. Again, a independent living preparation section was created in Chapter 409. And one of the exciting provisions to me and to young people is it specifically requires the development of procedures to access and manage personal allowance, which has not previously been in statute. Keys to independence is expanded to young people who are eligible for PES. It requires CBC lead agencies service population to include children who were adopted from the child welfare system when their families need support. Creates a new office of continuing care in DCF to serve young adults who have aged out of care either when they turned 18 or through extended foster care, by giving them a continued point of contact till they turn 26 and giving them the access to resources that are available to them as young adults. But some work on the Child Welfare Institute. Okay, we are, got a ways to go. Okay, so that's the end of the train of Senate Bill 80. The other big bill was Senate Bill 96, not quite as long as this one, but also a train. And it reorganizes the abuse hotline and moves some sections that are in 39201 to create a new section of 39101. And it reorganizes, I think, puts it in a more logical sequence to understand how the abuse hotline is supposed to operate. It adds new provisions of the bill and required reporting relating to the sexual abuse of children, juvenile sexual abuse, or those who have exhibited inappropriate sexual behavior. And it requires that services be provided in that least restrictive environment. It allows CPIs to investigate incidents that happened at school. And so provide some clarification about what's supposed to happen in those investigations. It adds reports of sexual abuse to the investigations that are part of the critical incident and rapid response team. So currently that's just death investigations. Now it will be sexual abuse investigations. Again, responsive to the reporting series about young people who were sexually abused while they were in care, and the department's response and investigation. So it's a direct response to that, as is this provision, which gives the legislature access to records within the Department of DCF that they want for their oversight purposes. It talks about everybody in Florida is a mandatory reporter. Some people are required to disclose who they are when they make the report. And this specifically looks at the responsibilities of educators when they are making a report. And if an educator fails to make a report, basically and is caught twice, they're to lose their educational license. There's a whole new sections related to the cross-reporting of sexual abuse of children or just abuse of children and animal abuse. So there's cross-training and cross-reporting with animal control. And it requires, so going back to the whole issue of the sexual abuse of children in care, when a CPI is investigating allegations concerning any child, this would seem to be intuitive, but they've put it into law. They also have to take protective action for the other children who are accessible to that perpetrator and not the subject of the allegations. So there were reports of children who the child was removed from an alleged sexual abuser, but other children were left in the care, some of whom were also then abused. So it specifically puts that obligation on the CPIs. Addresses institutional investigations. So these would be at our institutions, at group homes, and make sure that people that are being investigated know that they have the right to counsel at their own expense in that process. Just describes child advocacy centers. Two really important things: it updates sections of the law. Currently, family finding is an option for CBC lead agencies. Now it is mandatory, and likewise, so is kinship navigation. So everybody needs to do it, which hopefully everybody was doing it all along. So this was another exciting section for children's rights. So one of the main things we hear from young people is they want to know their rights. They want to know what's happening to them while they're in care, what should be happening, what their rights are. And so the legislature amended the existing Bill of Goals for Children and requires DCF to work with stakeholders to help kids know their rights. And it put some specific provisions at touch points where children need to be instructed about what their rights are while they're in out-of-home care. And it makes sure that there's a parallel bill of goal for caregivers that was passed, I think, last year. And this allows, it just revises a couple of provisions in it. Again, kind of clarifying that they are a placement option if a foster parent had a child who's reunified or moved for another purpose, exits care, but then comes back in, that they should be considered as a placement option. I'm very excited about the multidisciplinary team legal representation. This is a new section of law also, and it really recognizes the importance of multidisciplinary legal representation. That's the use of forensic social workers and peer support to work with attorneys that represent parents. And it gives the regional councils the option of creating those multidisciplinary models and accessing funds to do that. And so hopefully we'll just grow from there for all of parent representation. When I talked about one of those themes was supporting parents and caregivers, specifically law requires the creation of a foster parent information center. So foster parents can access information and get feedback from knowledgeable people, and specifically requires CBCs to provide kinship support. Some of them do a great job at it now, but that's not uniform. So now that's required around the state. We know that family foster homes can be what we used to call group homes. So they can have 6 dependent children and a total of 8 children before they need to get a foster, a waiver for their license. There's details for both lead agencies and for the managing entities that talk about conflicts of interest and other board operations. I thought this section was interesting. It requires the lead agencies to adhere to best child welfare practices in specific statutes. And those statutes relate to the goals for caregivers, placement and out-of-home care, parenting partnership, and the care of children, reasonable prudent parenting. So it is saying to the lead agencies, when we put stuff in the law, we think it's important and you need to follow it. It's not just advisable, it's now a requirement, and DCF will have to add that to the contract with the CBC lead agencies. It clarifies some of their publishing obligations about their data, kind of going back to that accountability from the past. Managing entities, those are the entities that DCF funds mental health through. they also have those conflict of interest and board obligations kind of parallel. The statute creates a commission on mental health and substance abuse and sets functions for that. So that's what happened to Senate Bill 90, the second train. I'm just going to skip through the items that failed, but I'm going to encourage you, when you get a minute, when you get these slides, to take a look at these bills, because when they're here this year, some of them were there last year, you'll probably see them again. This cross-reporting of animal abuse and child abuse was proposed 2 or 3 years in a row before it went through. So some of these provisions, even though they didn't make it this year, have them on your radar screen for going forward. And the last piece I want to spend a little bit of time on, and then we'll have time for questions, is I referenced early on the independent living benefit chart. We have updated this chart. It's a subject of a whole separate training, but a lot of you use this chart when you're working with clients and when you're making decisions. So this is, I don't expect that you can read that, but that's a kind of a view of what the first page of the chart looks like. And the purpose of the chart is to help you work through what will happen if a child is in one placement and you're thinking about moving to another placement or legal status, what are the consequences? So on this chart, the columns going down are licensed. I'm not going to read them to you, but they're the status of the child. So these are the open placement columns. And then there are columns about closed placement. And Florida law is complicated. Whether you're in a permanent guardianship before 16 or after 16 makes a difference. You know, when your adoption occurred. So there are lots of columns because lots of things change if you move the placement. And then the rows of the chart answer these questions. Who has custody? What financial support is available? When is medical insurance available? What those benefits are. So it's really important when you're making a decision, you know, like, gosh, it's really convenient to close this case to permanent guardianship when the child is 15 and 10 months. That can have lifelong consequences for the child. And you need to know what that is. The kid needs to know what that is, and the caregivers need to know what that is. And so we really encourage you to use this chart in understanding the complexities of the law relating to benefits. We have in that chart highlighted in yellow the impact of the current changes of Florida statute. I mentioned some of them as we went through, like the eligibility for aftercare change, the keys to independence. So that will highlight to you how the recent legislation changes. So I'm going to bring it back to, if you're a lawyer, please sign up for the Florida Dependency Law Center. And our contact information will be at the end. And we have 12 minutes to answer questions. So I am going to turn my PowerPoint off and stop sharing my screen. How do I do that?
You should.
My whole screen. I don't know. Stop sharing. It's not letting me stop sharing. Stop sharing. You don't need to see my kid.
There we go.
Okay.
Well, thank you for all that great information. Wow, that was a ton of work getting all that together.
So we got about 10 minutes for questions. How?
That's great. So, all right. So regarding notifying children of the location and contact information for siblings, is that only for siblings in foster care or all siblings, whether or not they're in care?
It does not differentiate.
How do we handle when it takes so long for out-of-state or out-of-county home studies?
I can't answer that.
Squeaky wheel. That usually works. As to post termination of parental right parents coming back and adopting the children, do you undo the TPR or does the parent adopt?
It's an undoing of the TPR. So it is not an adoption. So that has legal consequences for benefits because it's essentially treated as a reunification. It's a longer process. You know, it's not an immediate, there's a placement and supervision for some time after the placement. But when all is said and done and the court case is closed, it has the legal effect of reunification, which has, there may be times where it's more beneficial to adopt.
For anyone who's still wondering if you're going to get the PowerPoint, I promise you'll get the PowerPoint and all of the great resources that Robin pulled together. So you'll get an email from Zoom tomorrow with the recording and all the materials.
And
That
look
was
at
a
your
lot.
spam filter. Sometimes the Zoom stuff goes in your spam filter. So
Yes.
it will
Should
come. We'll
look
send
for it tomorrow afternoon, and you can always email me if you haven't gotten it. Okay, so now we're to the Q&A box. Lots of great questions, everybody. When a child is placed across the country, but another, I'm assuming they meet another sibling, is returned to Florida from that placement, is contact still supposed to be maintained?
Yes, kids are supposed to have contact with their siblings wherever they are. It's their family. And we promote healthy relationships. So yes.
How often should the periodic review be for siblings who are separated? Is there a certain timeline?
The statute says 6 months.
Right. If a sibling was previously adopted and there was a new child born into care, are we required to provide the child in care the adopted sibling's information?
Yes. Kids get to know their whole family.
Going right through it. All right. So if one parent surrendered their parental rights and one parent went to trial, would the surrendering parent be able to have their parental rights reinstated?
So yes, I didn't, because I was speeding through that part. There are specific grounds that TPR, the reason for TPR took place, that make you eligible for reinstatement. Surrendering is one of the grounds that makes you eligible for reinstatement. The other grounds are those related to case plan compliance or not substantial compliance, or so they're the case plan things. So if the TPR was based on any other factor, then reinstatement is not permitted under the statute, but definitely with surrender.
All right, here's a more complicated question. Who is supposed to determine what is inappropriate sexual behavior versus normal childhood sexual curiosity? How do we keep our kids from getting labeled and still protect them?
I can't answer that in this. Well, I can't answer that. It's not addressed in the statute specifically, although there is more discussion about inappropriate sexual behavior. But then we're really talking about advocacy, and I don't have that expertise to help you with that. But if you want to contact me offline, we can try to find some resources to help build better expertise on that.
Okay. Does the requirement of children to know their rights apply to children without attorneys?
Hell yes.
I knew your answer to that.
They probably need it more than the children that have attorneys, although clearly children that have attorneys need to know their rights as well. Absolutely.
All right. I had a feeling that's what you would say. Are there any penalties built in for non-compliance with the new statutory provisions?
Wow, that's a really broad question. It's really not set up as penalties. You know, unfortunately, we have a lot of rights and responsibilities that are in the statutes that don't have a direct, if you don't do this, here's what happens to you. But, you know, attorneys, flex your legal muscles. We have order to show cause. You know, we've got law. Use the law. Ask the court for what the, you know, entity or whoever is supposed to be doing. And if they don't do it, move to show cause and then to move from there. So, I don't think we do that enough. We need to flex our legal muscles.
The transition plan mandated when a Chapter 63 intervention change of placement takes place?
I don't recall. I can say that many times throughout the bill, Chapter 63 interventions are accepted out. I don't recall whether they're accepted out for intervention, but I would argue to anyone that's involved in them and whatever side that you're involved on, what the law is that's affecting kids is irrelevant. What their needs are require them to have a transition plan. And if you're representing an adoptive parent, they want what's best for the kid. They should be supportive of a transition plan. So even if it does, I would strongly urge you to attempt to have one, to do a transition plan.
For those asking about the CLE number, I put it in the chat. It's 210683. Again, it's 210683. And someone posted there was a problem posting the credits. Sometimes the system's a little funky, so I encourage you to try again later and let me know if you have any problems. Oh, this is a good question. Has any race equity related mandate been added to the statutes? Is there something planned to be added?
Not that I'm aware of.
I got the CLE number posted. Okay, are there any teeth in the law to enforce visitation with siblings after adoption, where the siblings are placed in different homes?
So when you get to that issue with adoption, the adoption order per statute can have an order relating to visitation of siblings, and that can be done without the agreement of the parents, as opposed to adoption orders of communication for other parents or other relatives, which have to be with the agreement of the adoptive parents. There is no statutory teeth to that requirement. So I would go back to, your general flexing your legal muscles to get the right thing for kids. And, certainly the consideration at the time of adoption about what those parents are willing to do should be part of that communication and that understanding of going into it, that, that this kid has a life outside of your family and should continue to be connected to those people. But it's not an easy answer, but it doesn't mean you shouldn't try.
All right. Here's one you'll like. Who is supposed to inform the children of their legal rights? Would there be an issue with unauthorized practice of law? Are there guidelines set so that the line is not breached?
So, who should be telling their kids their legal rights should be their attorney, but most of our kids don't have an attorney. And the statute under the Bill of Goals that was just changed, 394085, does talk about the responsibility of the department, which, it then delegates to the lead agencies to provide children the information about their rights. DCF has been in the process for quite some time of updating the rights handout. There's a brochure that was created 10 years ago or more that explains the basic rights. DCF has been working on updating that and providing information, written information to kids. And everyone involved with kids should know what their kids' rights are. But there is an issue of unauthorized practice of law, and there is an issue with, an ethics issue with attorneys that represent another party explaining rights to children. And DCF and parents and the guardian ad litem are all parties to the case. So their lawyers represent a party separate from the child. And, there's some, it's a minefield in some ways.
Perfect timing answering all those questions. Lots of compliments in the chat box, so I'll be sure to send that to you, Robin. But everyone is really appreciative of all the information from you and from Florida's Children's First. And I am sorry, it is my fault. I am terrible with numbers. Do not trust me to do your taxes ever. The correct CLE number is 2104970, N as in Nancy. Again, that's 2104970, N as in Nancy, and that will be sent out with the materials tomorrow in case you didn't have a chance to write it down. So thank you again so much, Robin and Florida's Children's First, for all the information.
Thanks, everybody. Sorry for speeding through. This will be posted. You'll get a link to the video, and I think it will be posted on Florida Legal Services YouTube page, which they have lots of awesome trainings, and the materials will be linked to that as well. And you are welcome at the end of the materials, when you get the written materials, our contact information. We are happy to help in any way we can with follow-up.
I really appreciate that. And yes, I will send out everything tomorrow. I promise. I know it's a lot to keep track of. So I'll send the CLE number, the recording, the materials, and the link to the YouTube page. So you'll have it all. Thank you, Robin.
Thanks,
Take care, everybody.
Bye-bye.